No, Papa. I know I started off with a late warning, so I figured I know I was late. I'm usually late, usually between like 5 and 10 minutes, depending on my coffee situation. So I figured once I was able to get once I hit the live button, I figured that people would come in. I had the decision in Dropbox, both the decision and the indictment. I had both of them in Dropbox, so it took me a second to pull them out because I mislabeled them in Dropbox. Imagine that. So it took me a second to pull it out and get things arranged and that stuff. I did put in the description that I was not going to put the documents on the screen. Um, because I do want to try to protect any personal information that is in the indictment or the decision. Hi, Chrissy. How are you? Hi, Hammer. Because ultimately, that is my main goal, right? Also, I normally don't do lives with my camera off, but I'm going to leave it off for this one. In the description, you will find a blanket trigger warning. And I think that trauma survivors in general, it is super heavy, right? Even if it's a topic of conversation, and that is not my intention. I don't want to cause people more pain. So if it's not something, if you're super sensitive to things like that, I would rather you just didn't watch. It's not that important to me. What is important to me is getting the facts out there. The narrative that has been portrayed on this platform is not one that I will tolerate. And I think that the survivors of the school deserve more than that. Hi, I see everybody. How are you? So they are so he was indicted on April 3rd. I don't think that it became public knowledge. I'm sorry, there are dogs hopping around in the back. Oh, come on, Papa. He was indicted on April 3rd, and I don't think that it became public knowledge to us until April 5th. And of course, I screenshot it wrong. So come on, Charlie, come with Sissy. Hold on a second. Let me get the dogs to chill out. Yeah, you hear them hopping around. It's crazy. Come on, Charlie. Come with Sissy. Don't spill my coffee, though. Come on. Good boy. Come on. Come on. I think he's getting old, so like his back legs are kind of going. So it says United States of America versus Geer, obviously. The grand jury charges, it says backgrounds from in or about 1987 until 2014, the Family Foundation, right, Chrissy? The Family Foundation School, and then in parentheses it says FFS, which is used as an abbreviation of the school. You'll see that a lot. Which opened in Hancock, New York, marketed itself as a boarding school for children with psychological, emotional, and behavioral issues. And I think that that's a really important part of this, right? Because our parents didn't know. Our parents thought that they were saving our life, right? And it looked on the outside like a good school, right? It had an award-winning chorus. It had sports teams. It was in a mostly beautiful place in the Catskills, right? So our parents were also manipulated, right? It was super. My mom, the first time that I told my mom that the school was abusive was actually I had run away. And when she was driving me back, I can remember being in the car and telling her, you just don't know what this school does to us. And she didn't believe me, right? Because the school had, they manipulated the parents to think we were master manipulators. And we were just going to say whatever it was that we had to say to get our parents to remove us from this place, right? So they had already had that covered. And essentially they did market themselves as that type of place. Two, it says victim one, a male child born in 1978, was enrolled in an offended family foundation school from or about the summer of 93 through in or about the summer of 94. So you will notice that there are 3 victims named in this, but there are many more, right? The reason he was able to be charged was because of the trafficking, right? I do know that there are students that were assaulted on campus trying to work with the feds to get that situated. And victim 2, a female child born in 1983, was enrolled in and attended FFS from February of 2000 until March 2001. Victim 3, a male minor child born in 1985, was enrolled in and attended FFS from the fall of 2000 until the spring of 2003. What's the issue with Paul Geer is that, most people with these types of depravities, they have a specific victim that they target. Paul didn't have that. He was a more of whoever was available or whatever caught his eye type person. At all times, FFS employed various facility. Hold on. Oh, sorry, Chrissy. I can't answer my text right now. I'll get to you after. At all relevant times, FFS employed various faculty and staff to supervise the children enrolled in FFS, including victim 1, 2, and 3. From or about 1992 through 2014, in parentheses, it says when FFS closed and ceased operations, the defendant, Paul Geer, was employed at FFS. During the period of his employment at FFS, Geer served in various roles, including music teacher and the school's choral director and family leader. So when somebody is called a family leader, that essentially means that they are in charge of the students in their family, right? One of the things about Paul, right, was he did have an award-winning chorus, right? And you have to understand how important Paul's role was in hooking new parents, right? Because that's what they used. That was part of the propaganda that they pushed to suspecting like parents, right? So Paul was in a position of authority, and Paul was pretty much given free reign and protected, right? I'm sorry, I lost the page. Let me go back. In his capacity as a family leader at FFS, Geer directly supervised dozens of FFS students of various ages, including victim 3. In his capacity as FFS choral director, Geer had direct access to victim 1, 2, and 3, who were members of FFS's choral program. That direct access included frequent one-on-one lessons between Geer and each victim. I know this came up in the live that I was in last night, One Wens and Randy's live. They knew that there were no cameras in the barn, and I would even go out on a limb to say that they did that on purpose, right? Like they knew, right? And so it was more like a do what you want, but leave it off camera. You follow me? There they go. They're chasing my cat. Sorry. Geer also had a direct role, along with other family leaders, in determining what disciplinary sanctions would be imposed on students, including, but not limited to, victim 1, 2, and 3. Family foundation sanctions were, in actuality, forms of corporal punishment and abuse. At all times, Geer was directly involved with the impositions of sanctions on victims 1, 2, and victim 3. So as a family leader, Paul would have been had the ultimate say in what sanctions these victims were forced to do. I think that in all of the cases, when they tried to disclose the abuse, they were often met with more sanctions, right? It was used as a way to control his victims, essentially. I'm sorry, I lost it. Let me go back. Sorry. Food deprivation, which included Geer forcing a student to consume food that was moldy or which the student had regurgitated, severely limiting a student's food portions or depriving a student of food altogether for extended periods of time. So this was a thing that was common, right? If a student was known to have an eating disorder, which if you have any experience with people that are victims of childhood SA, a lot of times they develop eating disorders to make themselves less attractive, right? So when you would develop an eating disorder, they would control your portions, right? And a lot of times these kids would then put on severe work sanctions, right? And they weren't getting enough nutrients to afford their bodies to then carry out these sanctions, right? And you got to remember, a lot of us, like, you're teenagers. So like the boys who are growing rapidly, they weren't giving enough nutrients to sustain their bodies, even without the work sanctions, right? Isolation, which included Geer placing a student in a small locked room for anywhere from hours to days. In the earlier days at the FFS, isolation involved being rolled up in a rug or blanket, which was bound with duct tape or other material for extended periods. In the later days of FFS, isolation involved being locked into a closet-like room for extended periods. In both circumstances, the student had no access to restrooms, resulting in the student being forced to urinate and or defecate on him or himself and the floor. So in isolation, you are forced to eat. You don't eat what like the house eats. You eat essentially dry tuna fish, sometimes with an English muffin, sometimes not. There are a lot of students who have severe food aversions from the family. They also force you to eat foods that you were allergic to. That did not always end well, obviously. Forced physical labor, which included Geer forcing a student to perform pointless but physically exhausting tasks for hours, including, for example, carrying hundreds of pounds of rocks between various points on FFS campus, only to be required to return the rocks to their original location afterward. That was a frequent one. Another frequent one I did hear come up in the live last night was digging your own grave. They did that often. We were told daily that if you did not comply or follow, their program, you were going to wind up dead in a ditch. That was a very frequent thing that we were told regularly. I know in the case last night that was discussed, they had, pretty much shamed the young girl because of her father. That was a very frequent thing. Their theories had very Freudian-esque tones to it, right? It always, I don't know how, but they always made some connection to like some sick sexual depravity and we were just kids, we didn't have the emotional intelligence that we have now as adults to understand what was happening. As a matter of fact, I spoke to that victim this morning and I said to her, she said, it's just crazy. Like you're there, right? And you don't believe that this is actually happening. Like your mind sees what's happening, but you just can't fathom that there are places like this that exist, right? And that's part of the problem, is that for years after leaving the family school, the statute of limitations is generally 5 years, right? We don't have our shit together in 5 years. A lot of us didn't even have our shit together after 10 years. Like it took time. So by the time the student was prepared and ready to face the trauma, the statute of limitations was up. So we were kind of like at mercy of New York just happening to open that window. Blackout, which involved Geer preventing a student from verbally communicating with anyone for weeks or months, including family, friends, and even other family, students, faculty, and staff. So this was common. Blackout was super common. I was there on blackout with boys the entirety of my stay. It wasn't really something that I was concerned with, although they thought I was. I was also on blackout with people that were there for 6 months or less. I was there on personal blackout with students that, like, we had negative contracts. The negative contract just meant like you could have been singing a song that wasn't like approved, and you'd be put on blackout, personal blackout. They did do, so when you come in, you do not speak to your family. I didn't speak to my mom for 30 days. And that if you, in the situation with Paul and his victims, he would put them on family blackout so that they couldn't tell their family what was happening. They couldn't disclose to anybody but staff who were essentially protecting him. Repeated psychological abuse, which included Geer engaging in table topic sessions, which were lengthy and often vulgar, during which Geer berated and demeaned a student in front of other FFS students and faculty until the student admitted, often falsely, to allegations of trivial and irrelevant misconduct. Table topics were, I feel like they're always, I feel like it was always irrelevant, right? And a lot of times we would just admit to whatever it was to get the berate to stop, right? If you didn't, you knew what was going to happen. You were going to wind up in isolation. You were going to wind up punished. So I think that a lot of students would just admit just to get it to stop. I know it came up in the chat last night. Students were also participating in these table topics. So it wasn't just, this is one of the reasons why the family was successful, right? Because they made you distrustful of other students, right? You didn't trust to say what you were really feeling. Now that we're all, united, they have a much harder time, right? Let me make sure this is the right page because I know there was a problem with the way, repeated sexual abuse, which included Geer engaging in various forms of abusive and non-consensual sexual contact with a student, including but not limited to forced oral and penetration of the student. Okay, so count 1 is coercion and enticement. The allegations set out in paragraph 1 through 10 are hereby incorporated by reference as if fully and set forth herein. In the summer of '94, in Delaware County in the Northern District of New York and elsewhere, the defendant, Paul Geer, did knowingly persuade, induce, entice, and coerce an individual to travel in interstate commerce with intent to engage in any sexual activity for which any person can be charged with a criminal offense. In that defendant, they used the disciplinary sanctions discussed above and his position of authority over victim 1, whose identity is known to the grand jury, to knowingly persuade, induce, entice, and coerce the child to travel in interstate commerce, that is from New York to Maine. So the first victim was in Maine, with the intent to engage in sexual activity with victim 1, for which the defendant could have been charged with a criminal offense, including gross sexual assault, a criminal offense under Title 17-A, Maine Main revised status section 253, 2G, 1994, in violation of Title 18 United States Code section 2422, and then in parentheses it's 94. This victim was before I got there, so he was the first. This is in 1994. Paul then threatened that he would kill him if he ever told anybody, and victim one was able to face him in his last hearing, and it was super powerful. Count 2, transportation with intent to engage in criminal sexual activity. On or about the summer of 1994, in Delaware County in the Northern District of New York and elsewhere, the defendant, Paul Geer, did knowingly transport an individual who had not attained the age of 18 years in interstate commerce with the intent to engage in sexual activity for which any person could be charged with a criminal offense. That is the, sorry, I have to switch pages. Defendant transported victim one, whose identity is known to the grand jury, who was then 15, from New York to Maine with the intent to engage in sexual activity with victim one, for which the defendant could have been charged with a criminal offense, including gross sexual assault, a criminal offense, and then it's the same code. There are many more. There are many more, but I don't know how that works, right? Because the statute of limitations is up, but I do know that the FBI is talking to other victims. Count 3, coercion and enticement. In or about August of 2000 in Delaware County in the Northern District of New York and elsewhere would be campus, right? The defendant, Paul Geer, did knowingly persuade, induce, entice, and coerce an individual to travel in interstate commerce with intent to engage in any sexual activity for which any person can be charged with a criminal offense. In that, the defendant used disciplinary sanctions discussed above and his position of authority over victim two, whose identity is known to the grand jury, to knowingly persuade, induce, entice, and coerce the child to travel in interstate commerce. This one was in Pennsylvania. Yes, for the most part, they were under the guise of school activities with the intent to engage in sexual activity with victim two, for which the defendant could have been charged with a criminal offense, including endangering the welfare of a child, in violation of Title 18 Pennsylvania Code Section 4304A 2000, in violation of Title 18 United States Code, it's the same one. Count 4, transportation with intent to engage in criminal sexual activity. In or about August of 2000 in Delaware County in the Northern District of New York and elsewhere, the defendant, Paul Geer, did knowingly transport an individual who had not attained the age of 18 years in interstate commerce with the intent to engage in sexual activity for which any person could be charged with a criminal offense. That is, the defendant transported victim two, whose identity is known to the grand jury and who was then 17 years old. Hold on, I gotta change pages. From New York to Pennsylvania with the intent to engage in sexual activity with victim two, for which the defendant could have been charged with a criminal offense, including endangering the welfare of a child. Count 5, in or about April of 2001. Count 5 is coercion and enticement. In Delaware County in the Northern District of New York and elsewhere, the defendant, Paul Geer, did knowingly persuade, entice, induce, and coerce an individual to travel in foreign commerce with intent to engage in sexual activity for which any person can be charged with a criminal offense. In that, the defendant used disciplinary sanctions discussed above and his position of authority over victim three, whose identity is known to the grand jury, to knowingly persuade, induce, entice, and coerce the child to travel in foreign commerce, that is from New York to Toronto, Canada, with the intent to engage in sexual activity with victim three, for which the defendant could have been charged with a criminal offense, including sexual exploitation in violation of Chapter C-46, Revised Statuses of Canada, Sections 153, 1A and B, in violation of Title 18 United States Code. It's all the same code at the end. Count 6, transportation with intent to engage in criminal sexual activity. In or about April 2001, in Delaware County, in the Northern District of New York, and elsewhere, Paul Geer did knowingly transport an individual who had not attained the age of 18 in foreign commerce with the intent to engage in sexual activity for which any person could be charged with a criminal offense. That is, the defendant transported victim 3, whose identity is known to the grand jury, who was then 16 years old, from, hold on, because that's page 6. I need 7. Hold on, I'm sorry. From New York to Toronto, Canada, with intent to engage in sexual activity with victim 3, for which the defendant could have been charged with a criminal offense, including sexual exploitation in violation of Chapter C46, revised statuses of Canada, sections 153, 1A and B, in violation of Title 18, United States Code, section 2423A, 2001. So when he was indicted, we didn't know. It took like 2 days to get it, right? I know another victim sent me a message the other day after they gave a recorded statement to the FBI. But I don't know how they can go about charging him, right? The statute of limitations makes things really easy. And I'm sure that they thought that they were in the clear for a long time. The hearing, there was 40 of us in the room, and there was 45, 50 on the phone. Right. Yeah. I think that he felt untouchable. Well, that's just my opinion, right? Like, because he felt, I know this came up last night as well, because he did work with children after the family school, but he was comfortable, right? He had protection. They knew what was going on, and they just kind of allowed it. It's really sick, and it's the people that own the school pretty much own the town of Hancock, right? So like they're in this position of power, and it's like we're in the same situation because they had power over us then. And one of Paul's neighbors found my TikTok and commented, and she said something like, I'm so disgusted he was my neighbor for 7 years, right? Because the people in the town are very much of the mind that, like the things that Jimmy says, right? We're spoiled brats. We're hardened criminals. Like anything that we say is not to be believed. And somebody recently said that when they ran away, the cop asked, they said, what goes on at that place? But for the most part, they just brought us back. We didn't have much of a say, right? Because our parents, when our parents brought us to the family, they essentially signed us over, right? We became, I don't want to use the word property because I think it sounds weird, but that's essentially what happened. They were in charge of us, right? Like we became their wards, right? And I think that I spoke to an attorney in the early 2000s who specialized in suing the troubled teen industry, and he was based out of Utah. And he said, well, in New York, the age of consent is 16. Did they have a court hearing for everybody that was there? And I was like, no, they never did any of that. Like the parents just kind of, they didn't know. And I think that, I know I've said this before, students that get an apology or like the parents that acknowledge the trauma that was done to us in that place, I feel like we're in a different place, right? The students, there's still a lot of students that have this anger, like, directed at their parents for the things that went on while we were at the school. And some parents even still are really in denial about the situation, right? Like, despite all the interviews and all the cases and all of that, like they still can't, this is just my opinion, right? they still can't acknowledge that they put their child into a facility that wound up causing them immense pain, right? And that always makes me super sad, because it was so healing for me, right? To get an acknowledgement from my mom, which then turned into her anger, right? Because she was also led to believe that this place was going to save my life, right? Now, granted, I had trauma before I came to, like, before I got to the family school, and it didn't help, right? Um, but I think as a parent, right, it's super hard to acknowledge that a mistake that you made caused your child's trauma, right? And I really try to, I was lucky, right? Because my mom addressed it, and my mom did an interview with me with the news station. Like, she was very much at the point where she was like, fuck this place. They took advantage of me, right? Like, she had anger towards it. And it's really, I actually, I feel super bad for the kids that aren't there, that they don't get that validation from their parents, right? I agree, my crazy life. And I'm sure it is. I'm sure it is. But like, and so the ripple effect, right? There's so much damage, right? There's damage to the student. There's damage in the family structure, like within our families, right? And so the sibling, like it just caused so much damage. Like the entire situation is just, there's no good could come of it. And I know that there are kids that, like Carolyn said, he saved her life, right? I would bet my life that that kid was a later generation kid, right? Because there certainly is a difference from when I was there to when they were about closed, right? Because the school did have to make some adjustments to conform to the regulations that were being, set. There are students out there that did not have a bad experience because they just kept their head down, learned how to play the game, and then kept it moving. You know what I'm saying? But that does not mean that there were not students who absolutely had a very hard time. What's happening, what blows my mind is that it's still happening, right? That's one thing that, like, I just can't wrap my head around it, because I can see all of the damage that has come from my school, right? I could see all of the lives ruined. I could see the kids that couldn't take it anymore, so they kill themselves, right? There's so many more programs like that. And they're still very much operating under this umbrella of deceptive marketing while harming children, right? It's right. Even one child's, like, I couldn't, I said this in a video directed at Jimmy the other day. And I said, like, I want to know if you think about it, right? Because I promise you, there are situations that replay in our minds over and over and over again. So, does the staff not have that? And if they don't, that is a severe issue, because I would I would be devastated if I knew that I hurt one person, one child, one, like, if I changed the trajectory of their lives, I don't know that I would be able to live with myself, right? So the fact that they don't see it that way is quite concerning, right? And then you do come into a place of, like, systemic abuse and the bystander effect, right? Like, I don't have to report it because somebody else will, and then it goes not reported for decades, right? For years. Utah does. So Utah does have a lot of, they have a lot of programs that are It's crazy, right? And then you have people like Dr. Phil who co-signed and sent kids to Diamond Ranch. Like, shouldn't you have done your research? And it's a huge network of educational consultants and counselors, and they all, even people from school districts, that are like a network. And I don't know if it's legal anymore, but I certainly know back then they were getting kickbacks, right, while raking in money. A kid that I was with, and I know that my mother's got these documents somewhere in this house because she wasn't the type to throw anything away. A kid dropped a bill from that he got from his parents because he is starting a legal procedure. And it was over 50, like over $5,000 a month. So like, you're charging our parents over $5,000 a month, and you're abusing us, right? And then keep in mind that when we are put in, like if we're in the corner or if we're in isolation, we're not going to class. We're stuck in that place for however long, right? So now our parents are paying for us to attend school that we're not even attending. It truly is crazy. It is crazy. Um, so I know Kendall said that she was going to do a live tonight on TikTok with a girl from a wilderness programs. Wilderness programs and therapeutic boarding schools, there's certainly like a synonymous relationship there, right? Like we saw, and this was actually, I found it super ironic that our friend Carolyn made a couple of comments about the family school and then went into talking about Jody Hildebrand. Um, ma'am, to some people, your husband was Jody Hildebrand. And that doesn't occur to you? The things that they did to their children, to her children, excuse me, were very prevalent. The same methods were the same tactics employed at the school that your husband worked at for 13 years. Another reason why you should not be the one to speak about it. I understand it's a topic, right? And I understand her having a connection there, right? However, this is not the chance to revive your channel. Okay? It's just not. You have displayed in the past 2 years that it's been being brought up on your channel that you are incapable of validating students' experiences from this school. I don't know how many times I can say it's not just me. Students as a whole, this community of survivors does not want you speaking about this on your channel. I'll leave it at that. Right. It's super inappropriate. And I can't believe somebody did tell me that she touched on it a bit last night, but is kind of dancing around it. I haven't seen it. I've been like super busy today, but I can't even believe that I have to keep reiterating it. It shouldn't be something that I have to keep on saying. I also think that it is super weird how the first night that I was in her chat, she told me that she was working with the investigation. Well, that's weird because in Jimmy's DM to me, he told me you weren't aware of what went on at that school. So which one is it? How could you be working with an investigation when you didn't know about it? It's not your place. It's not your place. And I understand how you may Also, let me just, I want to make this clear because I did get a message about it today. I don't mind people talking about it. I mind the abusers talking about it and profiting, right? We want people to talk about it because for 20 fucking years, we were told we were liars. We were invalidated while we were screaming from the rooftops what we dealt with at this place, right? We want people to talk about it. Kendall, drop your TikTok, right? Because that live is tonight. We want people to talk about it. What we don't want is our abusers, which I know that this might be hard for you to hear. He's an abuser. Any money that would come into your channel to talk about this situation would go into your household, and that is incredibly, incredibly inappropriate. If I were you, I would speak to a criminal defense attorney. That's what I would do. I would shut my mouth and deal with it. Right? And it's not about don't tell me what to do. No, it's about you having some respect, right? For the people that have been hurt by this situation, right? And it's not right. It's not right. And I promise you, you speaking on this will be the death of your channel, because I will scream from the rooftops that you were asked many times to stay out of it, to not talk about it, and you are outright disrespecting victims. And I don't think that that will go over well in any community. This is not your chance to revitalize your channel. Yeah, so Sarah, I heard somebody say something about it, but I didn't see it. So I can't really speak on things that I haven't seen. All right, so when we went to the court date, there was a gallery full of students. Paul Geer's wife was not present. I do also want to say this. It was very common for husband and wife to work at the school, right? It wasn't uncommon. His wife did work there for at least while I was there. She was not present at that hearing, which is strange to me because she knew, right? So if you already knew what was going on, why are you not there to support your man? The only thing that I could think of is because she knew that she would encounter a room full of students, right? And that probably would not have went well. While the judge told us in the hearing that he would not, he would have to think about the decision, right? Because he wanted to read the other depositions from the civil cases all come into play, right? And New York did a major bail reform a couple of years back. He really didn't have a criminal record. So we had to prepare ourselves for the fact that he may be bonded, right? He may be bonded out pending trial. On an ankle monitor, obviously, hopefully with a no contact order with children. But it was a real fear, right? Because the statute of limitations makes things super difficult. But what I will say is the state attorneys have been amazing. They've been amazing. It was the first time listening to the hearing was the first time that an outsider, right, relayed our experience so perfectly, right? We'd never had that before. We always had people trying to shut us down, call us liars. So when the state's attorney started talking, I can't explain the feeling, right? Because it's somebody that finally gets it, right? Um, we've waited a really long time for someone, anyone, to look at us and say, we believe you, and literally get it right. Right. It was very, it was a really powerful, and I know that, like, it sounds weird, right? But it was a really powerful moment, especially knowing that he was cuffed and shackled. And there were 40 students in the room and 50 of us on the phone, and you could see the number. So he knew that we were all there. It was a really good moment, right? And I think that it is a lot, for people to understand, right? I was talking to somebody about this, the victim from the case last night. We don't, like, outsiders, like, they don't get it, right? Like, they could try to empathize and relate to trauma, right? I'm not saying that, but the situation is so crazy, right? That, like, nobody wants to believe that this happens. You know what I'm saying? So the judge said that he was going to make a decision outside of court. Um, I think that we worried, right? We worried about that because of the possibility of him being bailed. This is the decision regarding him being kept, him being held. So it's United States of America versus Paul Geer. It says order of detention pending trial. Presently before the court is the government's motion for pretrial detention of the defendant who was arrested on April 3rd, 2024. Defendant requested a detention hearing, which was then held on April 9th, 2024. At the hearing, the government and defendant had the opportunity to present evidence. The government additionally presented statements by 3 crime victims under the authority of the Crime Victims Act. Both the government and defendant, hold on, I got to switch pages, have provided post-hearing submissions to the court. The court is prepared, to render a decision based on the proffers and legal arguments made by both parties. The exhibits presented, the indictment, and the pretrial services report. The defendant has been charged by indictment with, among other things, transportation with intent to engage in criminal sexual activity in violation of 18 U.S.C. 2423A. The government bases its motion for detention on the section of the Bail Reform Act that provides for a motion by the government in a case that involves a crime of violence. See U.S. 18-3142 F1 and A. For purposes of the Bail Reform Act, a crime of violence, there's quotes there, is defined in 18 U.S.C. 3156 A, 4, and C to include any felony under various chapters of Title 18, including Chapter 117. Because Section 2423 is contained in Chapter 117 of Title 18 of the United States Code and is considered a crime of violence, the government was permitted to move for detention based on both a danger to the community and a risk of flight. Additionally, the Bail Reform Act provides that subject to rebuttal by defendant, it shall be presumed that there are no conditions or combination of conditions that will ensure the person's return or the safety of the community. If there is probable cause to believe that the defendant has committed an offense involving a minor victim under various sections of the law, including Charlie, sorry, he's bothering my cat. She's about to beat his ass. Including 18 U.S.C. 2423, and then there's subsects here. An indictment returned by a duly constituted grand jury conclusively establishes the existence of probable cause for the purpose of triggering the rebutable presumptions set, sorry, I got to change the page, forth in 3142, United States versus English. Do you guys want me to read the law, United States versus English, the case law? Quoting United States versus Contreras, based on the charging instrument and the other evidence presented at the detention hearing, this court finds that there is probable cause to believe defendant committed the charged offense and that he is therefore subject to the presumption contained in 18 U.S.C. 3142E. The defendant has a limited burden of production to rebut this presumption. However, a defendant's presentation of rebuttal evidence does not eliminate the presumption. Rather, the presumption continues to be weighted along with other factors. The government retains the burden of proving danger to the community by clear and convincing evidence and/or the flight of risk by a preponderance of the evidence. United States versus Ortiz, 607F, Appendix X at 96. The factors for the court to consider include the nature and characteristics of the offense charged, the history and characteristics of the defendant, the weight of the evidence against the defendant, and the nature of the seriousness of the risks to the community if the defendant was released. Here, the defendant has met his burden of production of evidence that he does not pose a danger to the community or risk of flight. The defendant's burden of production only requires that he introduce a certain amount of evidence contrary to the presumed fact. Hold on, I got to switch pages. On other grounds by United States, the defendant's proffer of evidence, including information of the defendant's ties to local community and employment history, his role of caregiver to his stepmother, his health issues, and the particular fact that the plaintiff has remained in the area despite the accusations. Stop it. Accusations of abuse against him since the early 2000s. Okay, so when we were in the hearing, his attorney, this is what she used to argue him be released pending trial, was the fact that he has been being accused of abuse since the 2000s and he didn't go anywhere. Ma'am, first, let me just tell you that facing life in prison is much worse than having to pay a civil amount of money, right? It was wild that she even tried that. I don't think that it made a difference, but that's so you have context. The aforementioned information, coupled with the defendant's lack of criminal record, lack of a history of drug or alcohol abuse, and the lack of allegations that he has engaged in criminal conduct. Charlie, can you sit down? Sit. Leave her alone. Come here, Finn. He drives my cat crazy. He's obsessed with her. Likewise, reasonably disputes the presumption that he poses a risk of danger to the community. Charlie. The court finds the above information is relevant to the ultimate determination and satisfies the relatively low thresholds imposed by the burden of production. Charlie, I'm going to throw something at him. Papa. Charlie, go get him. There we go. As previously set forth, defendant's production does not stop. If you spill my coffee, we're going to have a problem. Hold on a second, because now Charlie is going after the Chihuahua because this is like my regular life. Stay, Papa. Yeah, Kendall, are you still here? I think she's a mod for her. I'm sorry, I lost my place now. As previously set forth, defendant's production does not eliminate the presumption that no conditions of release will reasonably assure against flight or dangerousness. Rather, the presumption remains a factor to be considered among those. Stop. Sit down. Sit down. Sit. Charlie, sit. Sit down. Papa, stop. He didn't even hear you. Sit down. I'm sorry, guys. No, go get it. There we go. Okay. The presumption remains a factor to be considered among those weighed by court. To this end, the court concludes that the government has failed to meet its burden to prove by a preponderance of the evidence that the defendant is a flight risk. However, the court finds that the government has sustained its burden to prove by clear and convincing evidence the defendant presents an unreasonable risk of danger to others and to the community, and that no conditions of release will adequately mitigate that risk. I will consider in turn the relevant factors which support my findings and conclusions. The nature and characteristics of the offense charged. The defendant is charged in 6 separate counts, including 3 counts of coercion and enticement, and 3 counts of transportation with the intent to engage in criminal sexual activity. The indictment alleges that on 3 separate occasions in 1994, 2000, and 2001, the defendant coerced, enticed, and persuaded 3 separate minors to take various trips for the purpose of engaging in criminal sexual conduct with them. The indictment further alleges that the defendant transported the same 3 minors across both state and international lines with the intent to engage in criminal sexual activity with them. As the indictment alleges, each of the alleged victims was students of the Family Foundation School, a school for children with psychological, emotional, and behavioral issues, operating out of Hancock, New York, where the defendant was an employee from approximately 1987 to 2014. So this is incorrect. He didn't work there when they first opened. I believe he went in 1992 is when Tony and Betty brought him in. FFS is a boarding school. Defendant and his wife lived on the school property in close proximity to the dormitories where the students lived. Defendant is alleged to have served in various roles during his tenure at FFS, including musical teacher, choral director, and family leader. In these roles, defendant directly supervised and had frequent one-on-one interactions with students of various ages. The indictment further alleged that defendant was an active participant in the application of various forms of corporal punishment and abused of the alleged victims during their enrollment at FFS, including but not limited to repeated psychological and sexual abuse. So I said this the other day, a lot of the staff members lived on property, right? When I got there, Paul lived above my dorm, which was interesting. There's been multiple victims that lived in that dorm. Weight of the evidence. The government's proffer at this stage of the proceeding establishment that defendant was employed by FFS and charged with the supervision and education of the alleged victims at the time of the alleged criminal conduct. The allegations contained in the indictment describing defendant's penchant for subjecting the minor victims to physical, psychological, and sexual abuse is corroborated by a substantial number of statements by other former FFS students who have documented their own inappropriate experience with the defendant as their teacher and mentor. The defendant's conduct is further corroborated by his own sworn statements. During the course of various depositions held in collateral civil actions alleging the abuse at the Family Foundation School, the defendant has admitted under oath to, among other things, identifying as a sex addict while at FFS, behaving, in quotes, badly, and otherwise engaging in completely inappropriate behavior with his students, including sexually explicit conversations, screaming and name-calling, food sanctions, and physical restraint. Defendant further testified that at the time he did not believe his behavior was inappropriate, but looking back, he agreed under oath that his behavior was indeed inappropriate. Defendant denies subjecting his students to sexual abuse. However, he admitted that he took a vacation, in quotes, to Maine with one of the alleged victims named in the indictment and recognized that he, in quotes, shouldn't have done that. History and characteristics of the defendant. Defendant is 57 years old and lives with his wife. He is also a caretaker for his stepmother. He has limited mobility and suffers from medical issues that the defense submits make it difficult to travel. As previously set forth, he has no history of drug or alcohol abuse nor any criminal record. There is evidence that the defendant treated with a mental health provider in or about the time he ended his employment at FFS. Although he purports to have maintained regular employment since his employment with FFS ended in 2014, the court notes that his employment in the interim was somewhat sporadic. As of January 2024, defendant was employed working remotely from home as a team leader for a call center. Defendant indicated that he had recently been terminated from this position as a result of the criminal allegations against him. He volunteered with the youth leadership organization during his tenure at FFS. He is also part-time choral director with his church. See discussion below. Nature and seriousness of the risk to the community. The coercion and enticement of children is itself a crime of violence and presents obvious concerns regarding danger to the children and community in general. Defendant argues that the remoteness of the alleged crimes and the lack of intervening criminal conduct in the interim is significant to establish a lack of dangerousness to the community. Although the court recognizes that this might be some evidence to establish that the defendant would not pose a safety risk, the court considers this small comfort in light of the seriousness of the crimes and the degree of harm it inflicts upon its victims. It is significant, that the United States has produced no evidence of any crimes on the list that occurred later than 2002 or 2003. The statute does not provide that the crime for which Martinez is being detained, it's a case that they cited case law, need to be recent, nor does it place on the United States the burden of proving a recent offense to justify detention. Furthermore, the court finds the government's proffer as to the risk of danger the defendant continues to impose on the community to be compelling. Although the defendant denies engaging in sexual abuse, he is admitted to engaging in other completely inappropriate behavior with minors, including that of a sexual nature, which admissions corroborate many of the allegations contained in the indictment. Furthermore, defendant proffers that he has been, in parentheses, it says, living with the allegations of abuse from his time as a staff member at FFS since the early 2000s. It's concerning, I'm sorry, I lost it when I switched pages. It is concerning to this court and indicative of the continuing danger defendant presents to the community that despite the defendant's knowledge of these allegations, clearly of a criminal nature, he continued to seek positions of authority and supervision over children. Between 2008 and 2015, defendant volunteered with a youth leadership organization where his duties included coaching a youth choir and traveling out of state with students. Defendant was permanently banned from volunteering with this organization in 2020. Defendant also maintained a live webpage advertisement for music lessons as recently as the pretrial investigation by the probation department, advertising services to those ages 13 plus. So the day of, thank you, Bluebell. The day of the hearing, that website was still up. It was down, but by the end of the day. Finally, defendant maintains part-time employment as the music director of his church, a position this court strongly suspects includes exposure to and interactions with minors. The defendant's continuing efforts to seek out positions of authority and supervision over minors, coupled with psychological grooming and victimization he is alleged to have utilized to coerce his victims, provides clear and convincing evidence to this court that he poses a serious risk of danger to the community. Moreover, the government proffered evidence of more than 75 tips regarding abuse at the Family Foundation School by defendant, through and including 2013, the year the school closed. Equally disturbing is information suggesting Equally disturbing is information suggesting that over 150 former students of the FFS have taken their lives in the past 30 years. I'm sorry. One individual in particular testified in front of Congress in 2008 about the abuse that he suffered at the hands of the defendant at FFS. He's talking about John Martin Crawford. The alleged victims have stated they continue to fear retaliation from the defendant and fear for their safety due to his continued presence in the community based on his past threats of violence and retribution towards them. The defendant's threats may have been made years ago, does not weigh against the detention in this court's opinion, but rather evidence the defendant's success in grooming and threatening his minor victims into silence for so long, and the continued risk he poses to the community in having done so. There is case law stated here. Hold on. See United States versus Monchel. The threat posed by the defendant to an individual or to the community need not be of physical violence and may extend to non-physical harms. The term dangerousness, as used in the Bail Reform Act of 1984, has a much broader construction that might be commonly understood in everyday parlance. Consideration or conditions of release. The probation department, having reviewed the facts and interviewed the defendant, issued a recommendation in favor of detention. I have considered carefully possible conditions of release that would adequately address the danger that the defendant presents and find that no condition or combination of conditions would mitigate the risk of defendant's further efforts to prey on vulnerable children or assure the safety of other persons in the community. It is well established that home detention and electronic monitoring may be insufficient to protect the community against dangerous individuals. And then there's case law. Home detention and electronic monitoring at best elaborately replicate a detention facility. Come on, Papa. Without the confidence of security in such a facility instills. If the government does not provide staff to monitor compliance extensively, protection of the community would be left largely to the word of the defendant, and they will obey the conditions. At a minimum, defendant's own statements evidence that he has been unable to recognize the risks posed by his egregious and inappropriate conduct toward and with children in the past. While the defendant proffers that his recent participation in deposition conducted in civil actions is a positive factor, this court believes that his evident complete lack of awareness of the seriousness and potential criminality of his alleged behavior is a factor that counts against him in terms of his present danger to the community. This, coupled with defendant's own admitted sex addiction and the serious allegations lodged against him, suggests defendant's inability to control his behavior even if he is released with strict conditions. The case law states, affirming district court's conclusion that defendant posed a danger to the community warranting detention, and noting that the alleged activities are of an addictive sexual nature that cannot be suppressed, simply be a restrictive set of bail conditions. And then it says, wherefore, it is hereby ordered that the government's motion for detention is granted, and it is ordered that the defendant is committed to the custody of the Attorney General and his designated representative for confinement in a correction facility, separate to the extent practicable from persons awaiting or serving sentences or being held in custody pending appeal. Defendant shall be afforded a reasonable opportunity for private consultation with defense counsel on order of court of the United States or on request of an attorney for the government. The person in charge of the corrections facility shall deliver the defendant to the United States Marshal for the purpose of an appearance in connection with the court proceeding. It's dated April 12th. Sorry, guys. I think that is the most damning, right? Like, and it's crazy, right? Because we're always told that you can't blame it on, like in the hearing, the state did say that there are 150 students that are no longer with us. And And his defense attorney said that it was wildly speculative to say that Paul Geer had anything to do with those deaths. I mean, there is certainly a strong correlation there. And one could argue that like we had issues before we were sent there, right? Maybe, right? But there's no doubt, and I know I said this last night in the chat. There are 572 students, just for reference, right? There are 572 of us in the biggest Facebook group that we have, which is closed. It's a private group. If you compare 150 students to 572, and you don't think that that is an outrageous ratio, then I can't help you, right? Like that's a little too many. Right. So he was, that's crazy, right? I kind of feel, oh, I love you. You didn't have to do that. I feel sorry for, uh, I feel sorry for the kids that are, uh, this is super hard to explain. So like, obviously we are so happy, right? That this, and I know that happy sounds awful, right? But it's so validating, right? So, but you also have, it brings, I don't think that I haven't thought about the schools as much as I have in the past 2 weeks in 10 years, right? Like there comes a point in time, and after trauma work, right? It's not your main focus anymore, right? The last 2 weeks, we lost another student the week that Paul was indicted, right? And I think that, I come across these comments in because I'm an admin for the group, right? And I come across these comments, and I've actually been debating removing the anonymous feature. That like we have the anonymous posting feature, and I've been thinking, somebody commented about it, and I was like, that's actually really a good, like that's a main point, right? Because what if somebody comments anonymously that they're feeling, suicidal, and we don't know who it is, we can't do anything, right? Because I think that for a long time we just felt so powerless, right? And a student, I spoke to him this morning, and I asked how he was doing. He's the one that I was friends with his sister, and she said to me one day when I had just gotten out, maybe I was out a few months, and she was like, "What's the name of that school that you went to?" And I told her, and she said, "They just sent my brother there." And I said, "Get him out, right? Like you have to get him out." Thank you, Brinzy. I said, "You have to get him out. Like tell your parents that this place is fucking nuts, and you have to get him out." And he didn't get out, and he did have it really hard, right? So I know that times like this, the students that, and I said, like he said he was struggling, and I said, just hold on, like this is what we've waited for. We've waited so long for somebody to be held accountable, right? Just somebody to fucking pay attention to what we're saying. And there, so I came across a video on TikTok the other day, and it was of a staff member who alerted the authorities to the family school years ago. Imagine that. She worked there for 2 weeks. She left, and she immediately contacted authorities, right? She apologizes for the trauma that we have gone through, right? She acknowledges it, and others can't, working there for a decade. You'd rather sit on your platform and deny it. And this, I'm gonna see if I could find it, because I did. She has a license, like she is. I'm gonna find it. Yes, right. You saw it. Somebody sent it to me the other day. I'm sorry, I'm looking for it because I recently followed her, so it's got to be in my recent. Here we go. And she says, like, she apologizes and says, like, I'm sorry, or something like that, something along those lines. And I thought to myself, my God, like, she gets it. And she wasn't even, she tried, right? But if you worked there for decades and you did nothing, and now you want to talk about it. Now you want to profit, right? Because that's ultimately what it would be, right? Now you want to, I'm trying to find the video, I'm sorry.
This is the Family Foundation School, also known as Alawan Academy, that housed children ages 13 to 18 that suffered from behavioral challenges and addiction. They sought out people in early recovery to act as staff, teachers, and counselors. I worked there over 20 years ago for 2.5 weeks until I started addressing abuse such as starvation, forced religion, isolation, seclusion, and public humiliation. The school was shut down in 2014 after a lengthy federal investigation of child abuse. In 2015, it was identified that several former students were completing suicide. If you are a former student of the Family Foundation School, I'm very sorry for what you went through. If you're still struggling emotionally from the trauma that you endured from that school, please seek out a licensed professional to help you process your trauma. This is the Family Foundation.
That is what a staff member that has remorse for what they witness would do, right? Now, granted, she is a social worker, like or like a therapist, right? But if students were leaving and contacting, child services, if we were leaving and doing that, right? How could you go to this place right? How could you go to this place daily and just ignore it for a decade? And I understand that in types of like that type of systemic abuse, right? Like, it becomes acceptable, but it is not acceptable. It is not acceptable. And you can't say privately, Jimmy, right, that you acknowledge the abuse. You can't do that privately, but publicly say we're spoiled brats. And then send me a bunch of messages about your wife's YouTube channel. Do you think I give a shit about the success of your wife's YouTube channel? I give a shit that you, who absolutely profited off of our abuse, and your wife plans on letting that happen again. That's what I care about, right? And from what I've seen in your marriage, you don't have much control there, right? But you should tell her to stay out of it, right? Especially because Paul Geer is the beginning. We are going to make sure that some way, somehow, we get justice. I personally, if I were in your position, I would retain a criminal defense attorney, or at least talk to a criminal defense attorney. I would not be talking about it on my YouTube channel. That's just me, though, right? That's just me. Right. And so that's what people that that didn't, like, she was not comfortable with what she was witnessing, right? And isn't it strange? Isn't it strange how all of our stories say the same thing, right? Because it's not like we talk every day, right? Do we have a Facebook group that we post shit in for fun sometimes? Sure. Do we have a Facebook group in case somebody needs support? We could give that support, because it is only students understand what student, like, it's the craziest thing, and I know it sounds crazy, right? But only we can understand um how it goes, right? Like, I don't know how to explain it, but it's just not right. It wouldn't be right. And maybe y'all don't care what's right, right? But students are asking you not to do that. And that's really all I could say about it, you know? It's unfortunate. Well, I don't think he's in denial about the school, though. I don't. I think that he is aware of what he witnessed. And I think that, look, I would have no problem if 2 years ago, when this shit came up, if he said, you know what? Yeah, I fucked up. I worked at an abusive place. Like, I had my hand, I would have nothing to say, right? But to say the opposite, um, denying abuse, martyring your husband, and now all of a sudden you want to flip that narrative to the victims matter, that no, that's just not right. It's not right. It's just not. And I said this to somebody earlier, like, I don't think she knew who she was when she blocked I'm sorry. I don't think she knew who I was when she blocked me. I don't think that it occurred to her what I do, right? What I have done. Um, she did try to send me an email and tell me she didn't block me, but Carolyn, baby, I'm not new to this, honey. All right. I know you said you had comment filters on, right? But there was comments that were commented seconds before mine and they were visible, right? Um, Multiple of my comments were not visible until after I made that video. So it's crazy. Right. That was weird to me, knitting. It was certainly a weird state. There was also something that he said, I used it in one of my videos. He said, I know these guys would take advantage of these girls. So did you know, or did you not know? Because that's what you said. I know some of these guys would take advantage of these girls, and I never wanted to be that person. I wanted them to know that there were good men out there. Those were your words. So how can you say that you weren't aware of sexual? He does admit to knowing about abusive tendencies. He does deny knowing about the sexual abuse. Right. See, knitting, that's the kind of person I am. Like, I'm the opposite, right? Like, I would put myself in front of somebody else to shield them. You know what I mean? I don't understand how you could you could work at a school, right? Let's be real. It was supposed to be a school, where, let's say, he was certainly there at the height of it, right? So it had to be at least 200 kids. You see them being abused daily, and you don't say anything. And then, 20 years later, you want to get on the internet and tell our stories, and you think that's right? Because it's not. If you had any intentions on telling our story the way it was, honestly, you would have done that when you were approached with the school, right? Because what would you have to hide? I did find that statement super weird, right? Like, you said some of these guys like could take advantage of these girls. What do you mean? What do you mean? It's really, it's super, it's weird to me, right? I don't understand that type of dynamic. Well, we'll see my crazy life. He kind of did in my DMs, right? But the time for private conversations, that has gone out the window like a week ago. My intentions are to help the FBI with their investigations anywhere I can, right? Because ultimately that is where it's going to matter. So if you send me a message saying that you knew about one thing or the other, that's where it's going to go, right? Because they're the ones that are trying to put the pieces together. And I think that was kind of nuts to give to me, but that's what it is, right? I'm not going to jeopardize any investigations. I did ask multiple students about them being active in the investigation, and nobody that I've spoken to, because that was the first thing that she said to me that first night, was that she's assisting with the investigation. It's weird to me how you could be helping with an investigation when you don't know anything. You don't know what happens at the school. You weren't aware of the sexual abuse. And I find it incredibly disrespectful for most of the DM to be about a YouTube channel. My friends are dead, and you want to talk to me about a YouTube channel. And that's where the problem lies, right? I don't give a shit about a YouTube channel. I care about the ones that are no longer here, okay? And the people that were abused getting justice. That's what I care about. I care that still to this day, there are 100,000 kids sent to programs like this. I don't give a shit about a YouTube channel that is run by somebody for the past 2 years, have had nothing but negative things to say about the students that are speaking about the abuse. If it's such a biased account, Carolyn, then maybe you're biased, right? We don't stand anything to lose, but you do, right? We don't have any criminality in this situation. Nobody's going to come and charge us with child abuse, right? That's not going to happen. So what do we have to lie about? What do we have to bother? And how can every single student have the same stories with the same themes? That is not possible. That is not possible. Right. And that's what I'm saying, Brandy. Like, you're messaging me about a fucking YouTube channel. I'm just going to be honest. That pissed me off even more. Like, I'm talking in videos about how you've invalidated victims, discredited our abuse, and you send me messages about a fucking YouTube channel. And then when, like, after, so I had emailed her the night that I went into her live. She emailed me back, and then in between the time that I went to sleep and I got up is when that live where she was yelling at Monica, being nasty, attacking somebody that is telling you that they're a student. And that was it for me, right? But she did send me another email, and that entire email is about her haters. I don't give a shit. I really don't. I do not care. I don't want to sound heartless. Like, the things that you've gone through on your channel are your problem, right? That has nothing to do with me. My issue is the things that you've said and continue to say regarding this school, its employees, and the abuse. Okay? That's what my issue is. So for you to send me an email detailing all of these things that happened to you, what does that have to do with anything that I'm doing here? Because they're in my chat, because they're in my comments. Don't you think that when you sat on your lives attacking these people for telling the truths about the family school, you should even apologize to them? You don't think that that's wrong? Because if you don't, maybe that's the problem here. It's like an issue with morality. That's crazy to me. They weren't wrong. And still, I've never seen anybody say anything about your husband being sexually assaulting anybody. I just don't understand, like, why do you do that? It's crazy to me. Hi. I don't understand. If you would have just acknowledged it, probably wouldn't be in this situation, right? But for those people that were saying that the school was abusive, and then you go on to call Liz's book bias, maybe you should read Liz's book, since you're so clueless to what went on at the school, right? You're so clueless what went on at the school, but you're helping the investigation. Anybody know how that works? Yeah, that's what I hear, Starlight. I know what you meant. Right, Brandy, that's what I'm saying. Like, me neither. So here's the thing. When I did the Hammer podcast, just so I'll back up so that everybody knows like the timeline here. When I did the Hammer podcast last March, maybe, somebody in the comments did say, the science teacher's wife has a YouTube channel, but I never followed up with it, right? And then when I was on Brandy's channel and I did the interview with her, it came up again because Brandy is involved in the true crime community. It came up again, and I looked at my phone and I was like, oh, she's live. So when I ended, I popped in there. I told her who I was, right? I wasn't on an alt. Wasn't on a troll account. Like, it was this channel. And she was just like, she was off put. I do have the entire thing screen recorded, because I'm no rookie, Carolyn. I'm no rookie, baby. So I wound up emailing her, and the things that she was saying, I know that staff can manipulate other staff. I know that they want blind allegiance, and if that's not what you're okay with, they will push you out. However, he was there over 10 years. That's not how it would have gone, right? So I sent her that email. She responded. Then that next night, after I went into her chat, somebody else went into her chat and said that they were a student, and she was just super sarcastic. Her tone was way fucking wrong, right? And then it was that happened, and then I was mad, right? So I didn't even answer her email. That's when I made the first video, right? I hadn't talked to y'all until after that. So like, what, and I'll be honest, and I said this to somebody else, like, I come from a hate community, right? And maybe she didn't know that, right? I am involved in several different hate communities, right? So I understand the psychology behind a hate community. You can't see me, but I have quotes, right? So she also didn't know I don't give a fuck about the number next to your name that says followers. I don't give a shit. I have burned 60 TikTok accounts telling truths about people that they didn't want told. Two of the people that I just went after, one has 4 million followers across different platforms and another has 2. Guess what? They're both in trouble with the law. Right? Because ultimately, I don't need to go back and forth with somebody on social media. I'll get to the work. But what you absolutely cannot do, is sit here, discredit us, and then because it's a hot topic, change your view, right? And make money off of it. It's just not right. And I understand that people on social media, like we all have different values and shit. Hi, Amy, right? But the people that you say are your hate group have shown students more support in the past week than you have in the past 2 years since it was brought. How is that possible? How is that possible? And I understand, like, there are people that'll say I'm hateful, right? There are people that'll say a bunch of shit about me, right? Why? Because they were once the topic of my conversation, right? That doesn't mean it's factual, but I promise you, just the things that I've seen on your channel, some mental health help might be beneficial, right? Because that's the kind of person I am. Even though you've done some shitty things and said some shitty things about students that are my friends or maybe no longer here, I still hope the best for you, for your husband. Even though he's abused my friends, I still hope that you guys get your shit right. Right, it's not. And it's not. It's really not drama either, right? Did the lawyer fund get to 20K to get a lawyer? Oh, I don't know anything about it. I did so I did come across something that said that people have lied and said that she's the defendant in a case. You are the defendant in a case, ma'am. I didn't even read it all, but that's factual. So how could you call people liars if they're just telling the truth? It's truly crazy. Yeah, I've seen a lot. I know people have shown me, sent me things, and it's a lot, right? I know I've said this. There's a lot there. But here's my thing, right? At some point, right, you become an active participant. Does that make sense? Right? There are people that talk shit about me to this day. They've been doing it for 2 fucking years. So I'm not here talking about them. Why? You know what I mean? And she shouldn't sour milk and cookies, right? It shouldn't be it should, like, and I can't, there are things in that I've done, on this channel that I've had to fall back from, right? And I don't think there's anything wrong with that. I take breaks all the fucking time. I just, like, I'm taking today off. You know what I mean? Yeah, it's not. And she shouldn't. Right. I can't imagine, like, an actual victim telling me, don't talk about this, right? And they just do. That's truly crazy to me. I know somebody mentions in the chat about Gannon's autopsy photos. That was a different creator, which she also had a problem with, which is wild, right? Like, I don't even, I don't, from what I know of the other creator, I'm not necessarily a fan of that other creator. But it's just crazy to me how there's issues there, right? It's crazy. Yeah, it's a different no, it was another one that also had problems with the wife of the staff member. Yeah, Natasha. But and I don't know, like I've been so busy with things um involved when the in the investigation and stuff like that, that I haven't had time to like deep dive, and I don't know that I even want to. But well, so I think that people started bringing it up to her, Irene. I'm not 100% sure. Um, but that's the impression I got, which I'm not mad about, right? Like I think she has this idea, like, why wouldn't I be upset with the ones that brought it out? We want it talked about, right? Like, yeah, I won't deal with that one. I have my own opinions and I'll just keep them to myself. We want it talked about, right? Like the more it's talked about, the more support we have, right? The more it's talked about, the more people know that these programs are a problem, right? That is why we want it talked about. We don't want an abuser to talk about it. We don't want an abuser's wife to talk about it. You know what I'm saying? I don't even know who that is. See, like I'm not necessarily there, you know what I mean? Like I know I have friends in all listen, Rosebud, let me tell you something. Let me tell you something. I come from drama, and this I say this a lot too, right? Because I do have friends in all different sides of like TikTok or YouTube, right? All over the place. Every single community has the same shit, right? And that is why um a lot of times things don't get done because they start with a goal, right? They start with a goal, and the drama takes away from that goal because people in the community start attacking people in the community. You know what I'm saying? That's what I say um when I meet, like I know what I'm doing. You know what I mean? No, absolutely not. It is not drama. I'm sorry if I read that wrong. Um I can't um but I understand drama communities, right? That's what I mean. Are you from Staten Island? Right. I can't. Hello, Starlight. That's actually why I never bothered following that person, because that to me is just, you know what I'm saying? I can't, I don't give a shit. To put a child's autopsy photos behind a paywall is something I will never support. And I followed that trial closely. It is oh really? I used to hang out in Midland Beach when I was a youngin. Well, she probably won't, right? And it's unfortunate because it really is a simple solution, right? It's such a simple solution. Just leave it to others that aren't you. And sure, it sucks. I'm sure it sucks to watch people that you have a problem with covering it. I bet. But you're in a different position than they are. You live with somebody that has abused children. It is not your place to speak on. Yeah, yeah, I can't. And that just, when she did that, I was just like, she did what? She did what? I can't eat because he was such a little cute kid. Well, see, that's the thing, right? As much as you can listen, the truth always comes out, right? I've been saying that for years, because people would lie about accounts or this or that, and they would always get caught. Why? Because the truth always comes out. It always comes out. Somehow, some way, you're friends with a group of people, somebody stabs somebody in the back, all the secrets get dropped. Like it's just the cycle of it, right? Right. It's unfortunate. It really is. And yeah. Well, see, that's the thing, right, Starlight? I think that she's been obviously watching my videos, right? And I know that, listen, it is super hard. I don't want to say that it is super hard to completely ignore and not respond to shit, especially if, well, actually, I'm the other way. If the more untrue it is, the more I just laugh and ignore it. But it's in this situation, right? Right. She's watching, and from what I've heard, she's really struggling keeping her mouth shut. But it would not end well for her, right? Because there are real victims that are watching the situation play out, right? And just like when she blocked me, right? She doesn't know who I know and who I don't, right? So I don't know. It would be in the best interest to just keep it shut. Like that's what I would do. But I don't know. Yeah, I'm gonna end soon anyway. Yeah, I don't know. From what I've heard, it's not that many anymore, you know? Yes, and I don't care, right? Because and that's one thing like I tried to make clear from jump, like I'm not gonna lie about you, right? I won't attack your family. I am a firm believer in kids are off limits. However, I do understand that when somebody opens that door, um, it how the other person responds to that is not I can't dictate that, right? So if you start attacking or contacting people's children, how they respond, you can't dictate it, right? And that's why for me, they're just off completely. It's not my thing. However, I don't know. I do know that she did lose a child, and that's terrible. So, I do have sympathy for that, but I don't think that that is a valid excuse for certain behavior. Does that make sense? Mm. Yeah, we're doing a bunch behind the scenes. But is Kendall still here? Are you still doing that live tonight? Um, I'll text her. I don't know if she dropped it in the chat because I was reading. Um, I'm texting her. I can't do it because I'm on my laptop and I would have to do it from my phone. She's Kendall Grant on TikTok. Oh, you know what, Starlight? I might be able to send it to you. I think she said 9 o'clock. She's doing a live with the wilderness program. I know she was. That might have changed. That's why I'm trying to wait for her to answer me. I know she was doing a live. She told me about. There we go. Can you drop your TikTok link in the chat though, so that they could before I end? Yeah. That's what I thought. I think she's Eastern. I don't know. Kenzo, can you answer them? I thought it was wilderness program. I could be wrong. I do think she is Eastern time, but I might be wrong. I've been like super scatterbrained lately. I have a lot. Yeah, okay, Eastern. They're waiting for your link. Is it popped? And I'm not, it is the wilderness program, 10 p.m. Eastern. Her TikTok is Kendall Grant. She texted me. She said her internet's slow. Sorry. I just can't drop it because I'm on my laptop. It's hold on. I don't oh, you know what? I might be able to do it this way. Give me 1 second. I got it for you. I appreciate it. I really do appreciate all the support. I know other students, some of them are in the chat. I mean, some of them have been watching and they've been I'm working on it too. They've been in my uh they've been in the comments and they're reading them. Even if they're not commenting, that they're reading and they've been really happy that finally we're getting somewhere, because for so long we were told that we were liars, so it really does make a difference. But they do appreciate it. I appreciate it. I got it. But I hope everybody has a good night. I didn't see that. I haven't been I've been trying to I didn't see it. I don't know how she does it, but she's live for like hours. I could never do that. Well, see, Mom of 8 is the same shit though, right? So like, how do you have such an opinion about Ruby Frankie and Jody Hildebrandt when you have an active participant in your home, right? It's crazy. It is solely crazy. But I hope everybody has a good night. And again, thank you so much. I will leave it up. I know I put it in the description that why I wanted to read it, and not the cat just fell off the couch. That cat. I wanted to read it because I did want to try to preserve any of, personal information and stuff. And I didn't want to leave. I'm going to leave the live up, but I didn't want to leave that type of information out. So I hope everybody has a good night. Yeah. And I will see y'all soon. Thank you. What do you want, Charlie?